Terminologies used in litigation. There are several terms used in the court proceedings. To a large extent, the terms used in the criminal proceedings differ from those terms used in the civil proceedings. Terms used in the criminal proceedings are as follows. Prosecutor. In criminal proceedings, the person who instituted a criminal case is regarded as prosecutor. The prosecutor is usually a police officer, DPP, Director, Public Prosecution, or Attorney General of the Federation or state. But nothing prevents the Attorney General of a state or that of the federal from briefing a private legal practitioner to prosecute an accused on behalf of the state. Criminal matters are usually prosecuted by the police. It is the office of the Director of Public Prosecution that prosecutes an accused person in the High Court on behalf of the state. Arraignment, the proceeding in which an accused person is brought to court, informed of the charges and asked to plead guilty or not guilty, is called an arraignment. Bench warrant. A bench warrant is a warrant issued by a judge commanding someone to appear in court based on his failure to obey a court order. An accused. In the criminal proceedings, the person whom the criminal case is instituted against is called an accused. He is called an accused because it has not been proved beyond reasonable doubt that he committed the offense. In the criminal proceedings, onus lies on the prosecution counsel to prove that the accused person committed the offense. The accused shall be treated and regarded as an innocent until he is proved guilty by the court in accordance with Section 36(6) of the 1999 Constitution. It is important to note that the person arrested by the police is not called an accused, rather he is called a suspect. Charge. In the criminal proceedings, the accused is charged for a particular offense. The charge has to do with the alleged offense brought against the accused person before the court. In other words, it simply means the accusation brought against the accused person. Charge sheet. The charge or the accusation brought against the accused is written in a charge sheet, which is a document completed by the police, which lists the particular charges brought against the accused. Beyond reasonable doubt, in the criminal proceeding, the burden is usually shifted to the prosecutor to prove all the elements of the offense beyond reasonable doubt, because the accused is presumed innocent until he is proved guilty. In the case of IGP against Adelabu, the court said that trial judge is presumed to be trained such that he does not have to direct himself. That prosecutor must prove all the elements beyond reasonable doubt. Therefore, before the court can convict an accused, it must have been observed that the prosecutor has proved his cause beyond reasonable doubt through the evidence adduced in the court. In other words, there must be preponderance of evidence or substantial proof. In order to prove his cause beyond reasonable doubt, the court will allow the prosecutor to call witness. Court suo motu, on its own, can issue a subpoena for the witness to appear to give evidence. Subpoena. A subpoena is a process that directs a witness to give testimony or submit evidence in the court. A recipient of subpoena is by that required to appear in court to give witness. Witness is important in the criminal trial because they are assumed to have actual knowledge of what transpired, which led to the trial. But it is to be borne in mind that court cannot admit hearsay evidence from any witness against an accused. Hearsay evidence. This is the evidence of a witness testifying as the truth of what the witness heard another person said, did, or heard. It should also be noted that there is no stipulated number of witnesses to testify against the accused as evidence. The prosecution counsel may call only one witness, or more if it is enough to prove his case beyond reasonable doubt. A witness who gave false evidence may be prosecuted for perjury. Perjury. In the criminal proceedings, the duty of the witness in the witness box is just to say exactly what he saw or heard, and not what he was asked to say or what he felt should be said in order to secure conviction of the accused. Thus, in testifying, court pays attention to the demeanor of the witness, to a very large extent determines whether or not the court will believe his evidence or wait to be attached to such evidence. A witness who gave false evidence has committed offense of perjury and can be prosecuted in the law court. It is important to note that an accused person cannot be compelled to give evidence because onus lies on the person who alleges. Except where he made some assertion, he must prove it because it is a general principle that whoever asserts must prove the assertion. Affidavit. a term you've likely heard referenced often. An affidavit is simply a written or printed statement made under oath. Redirect. When a lawyer questions his or her own witness, it is called a direct examination or examination in chief, after which the opposing side has the opportunity to cross-examine the witness. Redirect examination refers to further questioning of a witness that can take place after cross-examination. Conviction. In the criminal proceedings, if it is proved beyond reasonable doubt that the accused committed the offense, he will be convicted. In other words, it implies that the accused has been found guilty of the offense by the court. Where a person has been convicted on more than one count charge, the court will prescribe punishment for each of the counts and may order that the sentences either run concurrently or consecutively. For instance, a person convicted of conspiracy, stealing, and assault may be sentenced to 2 years imprisonment for conspiracy, 3 years for stealing, and 1 year for assault. Where the terms are to run concurrently, the convict will only spend 3 years in prison because the terms are running simultaneously. On the other hand, if the court orders the sentence to run consecutively, the convict will spend a total of 6 years in prison because the sentence will run once after the other. Sentence. In the criminal proceedings, sentence is the judgment of the court in respect to the offense convicted of. The sentence could be death, a term of imprisonment, fine depending on the gravity of the offense convicted of. The court may prescribe the maximum punishment for an offense or less, but never more. However, where an offense carries a mandatory punishment as capital offenses, the judge cannot vary it. Capital offenses carry mandatory death sentence, and this will not be reduced, unless where the accused was tried for murder but convicted for manslaughter. In pronouncing the death sentence, the court will say, "The sentence of this court upon you is that you will be hanged by the neck until you are dead, and may the Lord have mercy upon your soul." In armed robbery cases, a death sentence is by firing squad. It is worthy to note that pregnant women and young persons are exempted from death sentence. A pregnant woman found guilty of capital offense will be sentenced to life imprisonment, while the young person shall be detained until the pleasure of the governor is known. Moreover, before the death sentence is executed, the governor must confirm it. After a death sentence has been passed on the convict, the judge shall as soon as possible pass the certified copy of the death certificate to the Attorney General to advise the President or Governor, as the case may be, on the exercise of the prerogative of mercy. Convict. Any person who has been convicted by the court of law on any particular offense is a convict. If it is proved beyond reasonable doubt that the accused committed the offense, he would be convicted. Upon this conviction, he becomes a convict. A convict is no more innocent because his guilt has been proved. Ex-convict. Only person who was convicted by the court and has suffered the punishment imposed on him in accordance with the law or discretionary of the judge is an ex-convict. Autrefois convict. In the criminal proceedings, it is a principle of law that when someone has been convicted by the court for a particular offense and the person has suffered punishment imposed him by the law, the person should not be rearrested again on that particular offense. In other words, a person shall not be tried twice for the same offense. This is the rule against double jeopardy. That is to say, where an individual has been tried once, which ended in his acquittal or conviction, he was punished or pardoned, he cannot be tried thereafter. But if the person is rearrested, he should plead for the defense of autrefois convict. The plea is taken to bar the criminal trial. The ground for raising the plea is that the accused person was already charged and tried for the same alleged offense. Also, the trial resulted in either acquittal or conviction of the accused. These rules are also based upon the principle that a person cannot be tried for the same offense more than once. Discharge and acquitted. In the criminal proceedings, it is obvious that the duty to prove lies on the prosecution counsel, who alleges that an accused committed an offense if the prosecution could not substantiate his ground or prove it beyond reasonable doubt. The accused will be discharged and acquitted. Moreover, a convicted person may be discharged irrespective of the fact that the case against was proved. The court, having regard to the character, age, health or mental condition of the person convicted, may caution and discharge the convicted person unconditionally or conditionally, on his entering a recognizance without sureties to be of good behavior. Autrefois acquit. When an accused has been discharged and acquitted by the law court, it is a position of law that if the accused is rearrested on the same matter, he should plead for autrefois acquit, meaning that he has been previously acquitted of the said offence by a court of competent jurisdiction. Nolle prosequi. This is a Latin maxim which literally means shall not prosecute. It is the exclusive power vested in the Attorney General, AG, of the Federation, or a state within the Federation, to refuse to press charges or withdraw them when a criminal case has already been instituted. The Nigerian Constitution vests this power in the Attorney General. Section 174C and 211C provide that the Attorney General of the Federation and State, respectively, shall have the power to discontinue any criminal proceeding at any point in time, as long as a judgment has not been given. However, subsections 3 of both sections provide that this power should be exercised in public interest, interest of justice, and the need to prevent abuse of legal process. There are several questions that require answers. The first is whether the Attorney General can discontinue a criminal proceeding even when there is enough evidence pointing to the guilt of the accused. With respect to this first issue, my submission is in the affirmative, is that the Attorney General's power to enter a nolle prosequi is supreme and unquestionable. In Ezemo v. AG Bendel State, the Supreme Court held that the power of the AG is not subject to review by anybody, not even the courts. So when the AG exercises this power, he cannot be compelled to do otherwise or take back his words even by the court. The second question is whether the victim or their family members have any remedy. It must be clearly noted that a civil action to recover damages for improper or wrongful exercise of the power of nolle prosequi may be instituted against the AG. This was the decision in the Supreme Court case of AG Kaduna against Hassan. Therefore, a victim or their relative might just be able to recover damages if the Attorney General exercises this power wrongly. The third question is whether the AG must necessarily appear in person to exercise this power. On this issue, it is submitted that the powers of the AG are not necessarily exercisable by him in person. The AG is empowered to delegate the power of nolle prosequi to anybody he so wishes. This delegation, meanwhile, has certain crucial qualifications. This is deducible from the wordings of the relevant section of the Constitution. More so, the Supreme Court has affirmed this principle in the case of Saraki against FRN, where it held that the AG could delegate his powers to anybody within his department. It was further held that the AG could delegate his powers to other law enforcement agencies having prosecutorial powers, such as the police, the Economic and Financial Crimes Commission, etc. It is thus inferable that the AG can delegate his powers to an officer outside his department. However, this does not mean a criminal prosecution cannot be withdrawn by a prosecutor other than the AG. Section 75 of the Criminal Procedure Act provides that a prosecutor may withdraw a criminal prosecution against a person with the consent of the court or by the instruction of the AG. In conclusion, these aforecited judicial authorities point to the settled law that the power to enter a nolle prosequi is exclusive to the AG and only delegable by the AG. It is, however, appropriate to advise strongly that the power of nolle prosequi should only be exercised in good faith as the Constitution provides. The letter V in the criminal proceedings. The letter V, which is normally regarded as versus, is pronounced as against. For example, DPPV Okeke. That is, Director Public Prosecution against Okeke. State versus Mugbadigwu is pronounced as State against Mugbadigwu. AG Enugu State v. Chimaroke. Namani is pronounced as AG Enugu State against Chimaroke Namani. Allocutus. In the criminal proceedings after the conviction of a person by the court, he may be allowed or given chance to say something in respect of his conviction before execution of punishment by the court. Thus, the statements made by the convict are regarded as allocutus.